Assistant President.
Adam Searle.
Mr Assistant President, I lead for the opposition on the Norfolk Island Administration Bill. The opposition does not support the bill at this time. We will be moving that be referred to a committee. In fact, I move, Mr Assistant President, that the question be amended by omitting be now read a second time and inserting instead be referred to General Purpose Standing Committee number 1 for inquiry and report. Now, in addressing both the bill and the amendment, we note that in 2015 the Federal Parliament passed legislation that changes the way that Norfolk Island is administered. We note that the legislation abolished the Legislative Assembly of Norfolk Island from 1 July 2015, and we also note New South Wales has previously had arrangements with Norfolk Island for the provision of health and education services, but the ambit of this bill is potentially much larger than a simple fee-for-service arrangement. The bill provides that New South Wales may enter into arrangements with the Commonwealth for the effective application and administration of the laws in force in Norfolk Island. Such an arrangement may provide for the exercise of powers by an authority of New South Wales or an employee of New South Wales in or in relation to Norfolk Island. We note from the second reading speech from the government that education and health services are already being supplied on the island and to the island's residents by the state of New South Wales, presumably under an arrangement with the Commonwealth and presumably without the need for legislation. But, as we indicated, this legislation simply provides, as it were, an open check to an arrangement between the state and the Commonwealth. And apart from a bland assertion from the government that services will be provided, funded by the Commonwealth and resulting in no net cost for the state of New South Wales, the government has not provided the Parliament or the wider community with any real sense of what the financial arrangements or impacts will be or what the scope of services will be, although we accept that in the first phase it will be limited to health and education. We think the bill provides for what could potentially be the quite extensive extension of the laws of New South Wales into the lives of people of Norfolk Island. And this occurs because at the moment Norfolk Island has been governed by a mixture of Commonwealth laws and laws made by the Norfolk Island Legislative Assembly. But our understanding is that the local laws of Norfolk Island will be replaced through the federal regulatory power, effectively implementing through that federal regulatory capacity, extending what is the content of New South Wales laws, or some of them at least, to Norfolk Island, displacing their local laws. And it does so without any consultation with the people of Norfolk Island, without them having any right to representation, or even without any right of consultation with the New South Wales Government or the Parliament. In circumstances where so much is not known, at least by the opposition, about the background or the content of any negotiations between the Commonwealth, New South Wales and the people of Norfolk Island about these arrangements, we are hesitant to support the bill, at least at this stage. Hence our proposal that the bill should be referred to what we regard as the appropriate General Purpose Standing Committee number 1, for inquiry and report. And it is our view that such an inquiry should establish the implications of the extension of New South Wales's administration and legislation to Norfolk Island, and any safeguards or models of consultation that should be properly considered and introduced if this bill is to proceed. Should the move to establish this inquiry not be supported in this chamber, the Labor opposition will not be supporting the legislation, because we do not believe it is prudent to support such a potentially wide-ranging extension of our laws and the role and undertakings of our administrative bodies into another territory without a proper understanding of the potential implications of doing so. We note a bit of the history of Norfolk Island. It was discovered by Captain Cook in 1788 and became the place for convicts from Sydney to receive particularly harsh punishment. we note eventually that after all the convicts left, the empty island was deployed in 1856 by Queen Victoria's government to settle the Bounty mutineers. In 1856, by imperial order, it was declared that Norfolk Island should be kept separate and distinct from the mainland Australian states, and which of course federated in 1901 without Norfolk Island. In 1913, the UK essentially handed Norfolk Island over to Australia to administer as an external territory, and in 1979 it was granted a large measure of self-government with an elected parliament responsible for health, customs, immigration, tourism, culture and most matters of democratic concern, and for 36 years or so it's effectively been an autonomous territory. And we know there have been some issues about its financial sustainability and issues about whether or not the fishing licences collected by the Commonwealth should have been conferred on the territory. But we also note that although administered under these arrangements, and that the island did have, at least in some regards, a particular special identity. It competed in the Commonwealth and Oceanic Games under its own name. We believe they won medals in that capacity. We also believe they had representation with the Commonwealth Parliamentary Union and in some United Nations committees. Now, obviously the issue about removing self-government and moving to a different form of self-government, and I believe moves are underway to institute a local council. In fact, I think the council elections may have been over the last weekend. That's, of course, a matter for the Commonwealth Government. But the notion of extending or replacing the territory's current laws with essentially the laws of New South Wales does raise issues about what consultation there will be with the residents of Norfolk Island about laws that this Parliament may be making in the future, knowing that they may have an application to the residents of the territory. And we note also that the residents of the territory, or we understand a majority of them, are not happy about the arrangement, and moves have been undertaken to take their concerns, we understand, to the United Nations Committee on Decolonisation. And I have received, courtesy of persons formerly associated with the Norfolk Island Government, a joint opinion by Dr Christopher Wood, Senior Counsel, Dr Stephen Tully, Professor Vaughan Lowe QC and Richard Hoyle about whether or not Norfolk Island can or should be inscribed in the list of non-self-governing committee territories maintained by the United Nations. And of course, that opinion is of the view that Norfolk Island can be inscribed onto the list of non-self-governing territories. But that's a matter for the future, that's a matter for the United Nations, and of course a matter for the Commonwealth Government. But with so much uncertain, we don't think it would be a good thing for this Parliament to proceed down this path without knowing a good deal more. The legislation passed by the Commonwealth, essentially subject to orders to be made by the Governor-General, extended all of the laws of New South Wales to Norfolk Island. But my understanding of the last time I looked is that the Governor-General had made an order essentially holding back the rollout of New South Wales laws, and I think only some 7 laws dealing with health and education matters are intended to apply to Norfolk Island from 1 July 2016. But because the legislation before this House is open-ended, it allows the state to enter into any arrangement with the Commonwealth. And not just that, it envisages New South Wales authorities and employees exercising authority and their functions in Norfolk Island. Now, they currently do, according to the government's second reading contribution, and apparently they don't do that without legislative support. So I guess one question is, why is this legislation necessary if these services are already being provided? We assume it's to put it on a firmer foundation, but it must also be intended that a much wider array of services are intended to be undertaken in that territory by the New South Wales Government under contract with the Commonwealth. The problem is this: the Commonwealth now has all the levers to extend the content of New South Wales laws to Norfolk Island. It doesn't need the concurrence of the New South Wales Government to do so. It doesn't take much of a stretch of the imagination when you look at the continuing disagreement between the various states of this Commonwealth and the federal government about funding for health and education on mainland Australia, to anticipate that there may well be some dispute about the value of services provided. And you can see a situation where the Commonwealth Government, essentially by its legislative levers, extends to Norfolk Island more New South Wales laws and engaging the roles and responsibilities of New South Wales agencies to extend their operations to Norfolk Island. And it may be that the remuneration offered by the Commonwealth is, in the view of the Commonwealth, adequate to undertake those tasks, but in the view of the New South Wales Treasury and Government is not. And there is simply no way of New South Wales getting out of that difficulty if it is drawn more and more into providing further services and operations on Norfolk Island, even against our own wishes and inclinations, because it does not require the consent of the New South Wales Government. And once we get drawn in, we will find ourselves stuck and maybe the subject of ever-increasing obligations to that territory in a way that we did not intend at this point, and in a way that does ultimately lead to a cost impost for the New South Wales taxpayer. That is our fundamental and primary concern as New South Wales lawmakers. And so that is the fundamental reason why we cannot support the bill at the present time, because we simply do not have all of the financial details. And I'm not talking about absolutely every last detail, because obviously these are commercial contracts, but in a sense they're not competitive, so there's no reason why they shouldn't be matters of public record. But there's not even a real sense of what is to be involved as a result of this legislation. There is so much that is not known. We do not think it is safe, sound or prudent for us to pass this law and give impetus to this rollout of New South Wales law and activities on Norfolk Island. The second proposition, which I raised at the beginning of my contribution, is the one of the residents of Norfolk Island having a voice. Now, my understanding is that they have a voice at this upcoming Commonwealth election. They may voluntarily register to vote, and if so, they will be allocated, I think, to the federal electorate of Canberra in the ACT. Although Canberra, it must be noted, is a landlocked electorate. It's not contiguous with the sea in any way, so it's a little anomalous. But having said that, we understand that this is not a novel arrangement. I think a similar arrangement applies in relation to the Cocos and Keeling Islands as well, in relation to Western Australia. At least Western Australian law, I think, applies to those islands in the same way as it is proposed to extend New South Wales law to Norfolk Island. But having said that, the Norfolk Island residents will have no subnational representation. If our laws, or the content of our laws at least, are to be placed on Norfolk Island by the Commonwealth, we must be mindful that there should be some mechanism of consultation between this Parliament and Norfolk Island, at least so we know what their views are if these laws that we make may at some future point in time, at the exclusive fiat of the Commonwealth, to be made to apply to Norfolk Island. That simply does not appear to have been given any consideration. So those are our two prime considerations. The opposition has met with representatives from Norfolk Island, the Norfolk Island People for Democracy, Mr Christopher Magri, who was the Minister for Industry and Commerce in the former Norfolk Island government, and we've also had communications with a number of persons, private citizens as well as former persons formerly engaged in the administration, including some worrying representations from persons employed in the public services of the Norfolk Island. I see one public servant had her pay cut by 2% because she made a comment on Facebook adverse to the administrator of Norfolk Island, a former coalition MP, Mr Gary Hargrove, I believe it is. I also understand that persons engaged in broadcast facilities on Norfolk Island have been prevented from broadcasting any service that is critical of the removal of self-government or the raising of issues such as the bill before this Parliament. Now, those are allegations which are as yet untested, but they're very serious, and I would like to think that the Government of New South Wales and honourable members in this chamber wouldn't charge down this path without evaluating whether there's anything in these somewhat concerning and undemocratic measures, if in fact they have taken place. But, and I will begin to conclude on this note, I have also received a copy of a letter from Mr David Buffett, a former Chief Minister, I understand, of Norfolk Island, who also held ministerial responsibilities in both health and education at different times. And his letter is, I think, addressed to the Reverend Fred Nile, but nevertheless I think it's appropriate to read it onto the record, because I think the concerns it raises go to the heart of these matters, and I think should be very carefully evaluated by all honourable members before voting on this matter. And Mr Buffett says, and I quote, "I write to you with some reasonable knowledge of Norfolk Island affairs, having served as Chief Minister and held ministerial responsibility in both health and education portfolios at various times. The legislation has been brought to your Parliament at the request of the Commonwealth authorities. There has been no satisfactory Commonwealth consultation about the detail of this proposed legislation with the community of Norfolk Island, although claims to the contrary are made by Commonwealth ministers and officers. Similarly, I respectfully draw your attention to the fact that neither has there been consultation between the New South Wales Government, source of the services, and the community of Norfolk Island at large, where the services are to be placed, about detailed and preferred delivery of the services designated in the proposed legislation. Information, brackets both spasmodic and conflicting, bracket, filtering to the community signal Commonwealth directions are being given to New South Wales representatives, and New South Wales representatives conveying same to Norfolk Island plays in respective fields of education and health. However, you'll immediately understand the compelling difference between directions and consultation. Prospective recipients of these services in Norfolk Island are concerned about a number of aspects of the proposed legislation and seek to examine these concerns in detail. The preferred method of such an examination is to seek a referral of the bill to a committee of inquiry." I won't read it all, but it goes on to say, first, the matter of education. Presently, education facilities are accessed from K to Year 12 in a single Norfolk Island school. This service is provided by the New South Wales Department of Education and Communities, brackets teachers, curriculum, etc., and funded by Norfolk Island authorities. This arrangement commenced in 1906 and has continued to provide an excellent education facility in Norfolk Island. Over this century-plus period of time, the New South Wales Department has experienced name changes, as has the Norfolk Island Education Authority. A current Memorandum of Understanding, January 2015, stands in place and will continue to stand in place to deliver such services. Education will not be endangered in Norfolk Island should the above bill be referred to a committee of inquiry. Second, the matter of health. Presently, health services are provided by a statutory body, Norfolk Island, known as Norfolk Island Hospital Enterprise. This enterprise, to name its major components, employs the doctors, the dentist, nursing staff, radiologist, pathologist, pharmacist, runs an aged care unit on the same premises and a 24-bed hospital. The facility is supported by the New South Wales Department of Health, South Eastern Sydney Local Health District. As with education, the current Memorandum of Understanding 2013 stands in place with the South Eastern Sydney Local Health District. Today, that is the 26th of May, which is the date of the letter, I have had a discussion in Norfolk Island with the CEO of the District Authority, and he confirms continuity of the existing health services beyond 1st July 2016. His services are not dependent upon the proposed New South Wales legislation. Notwithstanding the significant revision of responsibilities for delivery of a range of services in Norfolk Island, brackets principally a migration of responsibilities from a Norfolk Island authority to a Commonwealth instrumentality, bracket, education and health services would not be interrupted in Norfolk Island by referral of the bill to a committee of inquiry. I do seek your support to refer the Norfolk Island Administration Bill, No. 2016, to a committee of inquiry. And he provides his contact details. Mr. Assistant President, I find that representation and many like it that I have received over the last few weeks compelling. I think there are a large number of questions that we have not had answered, and which I actually think would be unfair for the Honourable Parliamentary Secretary to have to address on the fly. For example, I'm sure she'll give it a go, but for example, what steps has the New South Wales government undertaken to appraise itself of the application to the Decolonisation Committee? Is there anything in that claim from residents of the island? Is there a potential embarrassment for the state of New South Wales if we are seen by international authorities to be aiding and abetting recolonisation, for example? Is it a matter they've even looked at? If they've looked at it and they're convinced utterly that there's nothing in it, well, it'd be good to receive that advice, presumably furnished by the Solicitor General. But I would hazard a guess that that has not taken place. Before honourable members vote on this legislation, particularly if you intend to vote in favour of the legislation, a full understanding from the government about, apart from health and education, what else is intended to be covered by this legislation in future agreements. How much money is the Commonwealth putting on the table? Is that adequate, according to Treasury advice, to cover the costs incurred by New South Wales? What measures are in place to stop the Commonwealth extending obligations of New South Wales agencies and authorities and employees to provide services on Norfolk in a way that we don't find ourselves getting drawn further and further into an ever-extending financial commitment? What mechanisms are in place to resolve a difference of opinion between the Commonwealth and the state of New South Wales about the cost of providing service X, whether it's health, education, or some other future service to be provided? I don't like the term thin end of the wedge or the slippery slope, but really by embracing this legislation at this time with so much unknown, there is a risk that we are effectively giving a blank cheque to an ever-increasing commitment by New South Wales and its authorities to provide services on Norfolk, and there is no real guarantee that that won't cost the New South Wales government and taxpayers in the future, because we don't know what mechanisms are there to protect the public finances of this state. And again, I conclude by just drawing attention to the democratic deficit. I understand that there's a lot of additional things that will be in place in Norfolk Island. I think Norfolk Islanders will have to pay income tax from the 1st of July. That's fine. Other Australians do that. But they will not be heard in the deliberations of this Parliament when we make laws for this state in the future, even though our laws may be then made to apply to Norfolk Island and its residents to the exclusion of domestically made Norfolk Island law. That is troubling. There should at least be some mechanism for consultation. Too much is not known. In our humble view, there are too many risks to support the legislation at this time. Rather than simply say no, we propose an inquiry by GPSC. One, we understand that 1 July is not that far in the future. Obviously, a short, sharp deliberation could be undertaken. GPSC 1 has done that before, say, for example, with the electricity privatisation. That was dealt with in a matter of weeks. But given that letter I've just read onto the record, it appears that for the ongoing provision of health and education services, 1 July does not need this legislation to ensure the continuity of those services according to that letter. So I'm not saying that the committee inquiry should be lengthy, but it should. We should take the opportunity that we have to get to the bottom of these concerns that I have raised, that have been raised with me, and no doubt with other members in this chamber. My understanding is that when the Norfolk Island representatives came here a few weeks ago, and they certainly met with me, I know they met with other members of this House, I believe they sought to meet with representatives of the New South Wales government. I'm not sure whether they did so. I look to the Parliamentary Secretary to give us a full report of the interaction between the New South Wales government and the representatives of the Norfolk Island People for Democracy.
I'm sure he has.
Well, I will suspend my judgment until I hear from the Honourable Parliamentary Secretary herself. But notwithstanding any response she may make, I think it's incumbent on us to evaluate these issues for ourselves, to get to the bottom of these matters, to ensure that there are no risks for the taxpayers and the Government of New South Wales, or that if there are some risks, that we can take some steps to safeguard them. I don't think accepting a bland catch-all assurance from the Parliamentary Secretary on behalf of the Government that there will be no cost to the New South Wales taxpayer or the Commonwealth will cover it all, that may well be true, at least for the near future. But as more services are required of New South Wales authorities, as more New South Wales laws are imposed upon Norfolk Island and its residents, that may not always be the case. Let us take this opportunity to proceed prudently and cautiously. Let's have that inquiry. When it reports back, we can consider the bill at that point with the additional information we then have. To do anything else, to rush this through without that inquiry, I think would be risky and imprudent, and I think, frankly, would be irresponsible, and we won't be party to it.